If you're charged with a crime in Madison County, you may qualify for something called the Pretrial Intervention Program, also known as the PTIP program. What these programs do is they permit a person who is guilty of a criminal offense to avoid a conviction if that person is willing to accept responsibility for what they did and successfully complete a counseling treatment program. So who qualifies for the Pretrial Intervention Program? Generally, the less serious your crime and the less your criminal record, the greater odds are of being admitted into the program. Now, there are certain people who are automatically excluded. If you are charged with a Class A felony, which is the most serious level of felony in Alabama, you're out. If you are charged with a crime that involves serious bodily injury, serious physical injury to another person, they're not going to let you in the program. The program is only available to people who are willing to confess and write a written confession. Who decides if you qualify? The assistant district attorney who is assigned to your case has the absolute discretion in deciding whether or not you can get in the program. So how do you get in the program? You should speak with your lawyer. Your lawyer can negotiate with the assistant district attorney. He can present you in the best possible light, and he can advise you as to certain things that you may do to help increase your odds of getting into the program. How long does the Pretrial Intervention Program last? The length of the program depends on a couple of factors. One of them is, what is the nature of the initial charge? Some charges, like drug charges, they may want you in the program longer. It is the people who run the program who decide how long you're going to be in it. So if they think that you need 2 years of counseling and not 6 months, you're going to be in the program longer. Other times, it may be the circumstances involving the case itself. For example, somebody who's charged with a theft case and owes restitution, well, they may not be able to pay back the restitution in full within 6 months. They might need a year, they might need 2 years. So there's a variety of factors. The default length of the program is 24 months. However, there are specific individual programs that can be as short as 6 months. What does the program cost? I can't tell you an exact amount because it's determined by a variety of different things. You're going to have to pay an admission fee, and that's between $100 and $300, and that's dependent on what it is you're charged with, as well as when in the process you decide to go into the program. If you wait longer, the fee can go up. In addition to that, you'll have to pay supervision fees, and you're going to have to pay for counseling. You may have to pay for restitution. So unfortunately, I can't give you an exact amount. I will say that generally it's between $1,000 to $3,000, but of course other factors can alter that one way or the other. What happens if you fail out of the Pretrial Intervention Program? Well, you're going to be prosecuted. If you recall, when you got into the program, you would be required to write a confession. You got to say, I did it. You give that written confession to the prosecutor, and there's an agreement that says, hey, if you fail the program, when they choose to prosecute you, which they will, they can use that written statement against you in a court of law. Now, does that mean that you will be convicted? There may be other options for you. I've managed to avoid convictions when somebody has flunked out of this program, but it's harder to do so, and you're in a greater position of legal jeopardy. You need to talk to a lawyer if you flunk out of the program. If you complete the Pretrial Intervention Program, are you going to have a criminal record? The answer is you will not have a criminal record for having been convicted of a crime, but you will have a record for having been arrested. And of course, that's not a good thing either. Fortunately, Alabama law offers an option for people who have either been found not guilty of a crime or who have had their charges dismissed. And that option is something called expungement. We have an expungement law, and expungement permits people in many circumstances to have their criminal record erased. But there's some hitches. Number one, it can't be a conviction. Number two, if it was a dismissal, it can't be a dismissal on some certain, there's 50 crimes that are listed as violent crimes that a dismissal won't do it. They have to be a not guilty. So you should talk to a lawyer if you've managed to have your case resolved without a conviction, and your lawyer can tell you whether it can be expunged or not. I hope that you found this video to be helpful and informative. If you have legal questions or if you're in a legal jam, feel free to give us a call. Our phone number is below. If you like this video and you want to give us a thumbs up, that's very helpful. And if you want to see more of these law-related topics, just hit the subscribe button. Thanks for watching.